Hello, my name is Sheri Abrams. I'm a special needs planning attorney here in Northern Virginia. I'm here at home clutching my Lysol spray and my cookies, the two things you need in a pandemic like this. However, the other thing that you need to consider is the need for special needs planning at this time. I have worked in this area now for many years, and I always say to clients, hope for the best, but plan for the worst. And this is the worst, in my opinion. So what do? You need to start thinking about special needs planning for your children who have special needs and disabilities. If not, you will be, unfortunately, not planning for the worst. So now is a good time, I believe, to give you an overview of how special needs planning works and the necessity to do it as soon as possible. And this really is for parents of children with disabilities and also for grandparents who are our most vulnerable during this pandemic. You need to immediately consider updating or doing your estate plan to reflect the need to protect the benefits, the public benefits of your grandchildren and children. So with that said, I'm going to bring up a slide presentation that I have prepared for everybody. And we'll go from here and try to give you an overview. Feel free to call me or email me with any questions. I may do a whole nother video with the questions and answers at some later time, but feel free to contact me. A little bit about me. I've been practicing this type of law for over 24 years. I have the credentials to prove it. I've also authored a planning guide for children and young adults with special needs and how to protect your child through this, and that is available for free download on my website, sheryabrams.com. I also have a book on there on Don't Gamble with Your Social Security Disability Benefits, also available for free download on my website. So you should maybe get those, but also see the other information on my website of topics perhaps that I'm not going to be touching on today, including legal guardianships at my website. Also, I have a blog that, the Virginia Disability Law blog, that has some great information on everything to do with disability, guardianships, estate planning, Social Security disability, special needs trust, special needs planning. I also have a free monthly newsletter that goes out. Please consider signing up for that at my website. And also I have social media presence on Facebook and so forth. You may want to follow me on those things and to get more current information as time goes on. I first want to start about discussing about what type of benefits fall under Social Security disability benefits. There are really three types. One is based on your own work record, Social Security disability, also called SSDI, Title II, or DIB. Then there's supplemental security income, which is known as SSI or Title 16. And then there's disabled adult child benefits, also known as DAC. Now, because of what we're talking about today, I'm going to concentrate strictly on SSI benefits and how they work with special needs trusts, because that really is the big topic and the big need that people have in a hurry given this situation with the pandemic. Now, Supplemental Security Income, or SSI Title 16, is a welfare type program, so it's a public benefit. And that's why your children or grandchildren who are 18 and older can access this program because they never had to work or work very little. The main thing, however, is that it's limited how much income and resources the person has. In general, and for any SSI case, an individual can only have $2,000 in their name. So therefore, if a grandparent or a parent were to leave them money in an inheritance or gift or anything like that, they could lose their benefits or not qualify for it at all. And it's money that they're leaving on the table in that way. In Virginia and in most states, the most that a disabled person can receive on SSI is $783 a month, and that's in 2020. It goes up every year. Some states have more, but Virginia, it's $783. So it's something that you want your child or grandchild to be able to access, and you have to be careful that they don't lose that benefit. So that's why we work in special needs planning so that that does not happen. Also, when somebody receives SSI benefits, they get Medicaid immediately. And Medicaid is free, and for a lot of people, Medicaid is a big thing to get. So you won't want to lose the Medicaid that comes with SSI by losing the SSI. Also, there are other public benefit programs like Medicaid waivers and other types of benefit programs that you would lose if your child or grandchild has more than $2,000. SSI benefits will start as a date of application, and it doesn't, there's no benefits for any kind of dependence. So again, it's strictly for the child or grandchild. And it's important to note that the money that they look at for someone turning 18 is their own benefit, not parents. Under age 18, a parent's income and resources are deemed to the child. So that's why at 18 is when a disabled or special needs child should consider applying for benefits. Now, how then will you as a grandparent or a parent leave money to a child, grandchild, without them losing their benefits? That's why we have what is called special needs trusts, also called supplemental needs trusts in certain sectors. But I'm going to refer to them as a special needs trust. And that is a trust that is used to hold assets, money, property, what have you, for the benefit of the disabled person, but it is not something that is counted as belonging to the disabled person, so therefore they don't lose eligibility for benefits. Now, it's intended to supplement the funds that they have for living expenses that they should be receiving from public benefits. Now, again, it's for and used for to improve the quality of a disabled person's life. It's those added things that they need. Some is very important for medical insurance and so forth, but some may be just extras that you don't consider. Therefore, like a trip to the barber, or cosmetics, or anything that would make them feel happier, or have a better life, a better quality of life, a vacation, any kind of transportation needs they may have. So that's why it's important that there is that availability, because even if they're on public benefits, it doesn't pay for everything. So again, the main purpose of a special needs trust, or SNT as we call them, is to protect the person from being disqualified for SSI and other types of public benefits. Another benefit is that the disabled person doesn't have control of the money. There's a trustee. So there would be help with the financial management. There is no risk that someone would take advantage of the disabled person and perhaps convince them to give them the money. Because there is a trustee, that's not something that you have to worry about. Who is eligible to have a special needs trust? Anyone who has any kind of physical, mental, or intellectual disability as defined by the Social Security Act. And that really is very lenient as far as what is considered disabling. And you don't need to receive Social Security disability or SSI benefits to be able to qualify to do a special needs trust. Most people that I see have some kind of disability, and therefore we have no problem doing a special needs trust for them. Now, there are three types of special needs trusts. There's a self-settled or first-party special needs trust, which you may hear as a D4A. There's a third-party special needs trust, And there's something called a pooled special needs trust, which is also referred to as a D4C trust. And I'm going to touch on the top two, the self-settled and the third party. The pooled special needs trust is run by in Virginia, the ARC of Northern Virginia. There's also Commonwealth Community Trust down in Richmond. They're the ones that do the pool trust, and that's a whole nother subject that I'm not going to touch on today. Those are something of which you set up with these agencies, or depending on the state, what they who has developed the pool trust, but you yourself are not in control of the money. You're giving it to somebody else, which there is different people who would fall into the need for that. But personally, I like to have a person have their own trust with the parents or the grandparents starting as the trustee, and then maybe a family member or a sibling, so forth, being the successor trustee. So again, the self-settled or first-party special needs trust. So that would be if a disabled person has their own money and you want them to qualify for public benefits. And that would be if they get money from a lawsuit, or someone inherits money before it can be put into a third-party special needs trust, meaning that the person who has passed away before they pass away did not do what we're trying to do now, to do planning so that the money doesn't go directly to the disabled person. So that has not occurred, and the money then goes directly to the disabled child, and therefore we have problems and we don't want to lose the public benefits. Then we could do a first-party special needs trust. The major problem with the first-party special needs trust is that they have a payback provision. So if the person who is the beneficiary of the trust, the disabled person, when they pass away, if they accessed any Medicaid benefit, that has to be paid back. So it really is not a good situation, especially if it is inherited money that somebody else, let's say grandma, has given to the person. Grandma may really want, if once the grandchild passes away, that the money gets given to other people, what's left in the trust, other grandchildren, for example, but that doesn't occur because it has to go to Medicaid. So that's one of the reasons that the first party is not the best situation. Also, it's limited as who can establish a first party special needs trust. The disabled person, a parent, grandparent, legal guardian, or the court can establish. So a sibling, for example, could not. Also, the special needs trust must be irrevocable, cannot be changed, which limits the flexibility that we'll see in the third party special needs trust, which that's why I prefer that. Also, it must be established and funded prior to the disabled person turning age 65. So that is very important to keep in mind. We can't establish this later than that or fund it. Now, there's also a form of a first party special needs trust for people who have been in the military and get a survivor benefits, sometimes called a 55% plan. If your disabled child is able to access that survivor benefit, then you want to set up a special first party special needs trust that will allow that your child to be able to access that benefit from the military, but also be able to keep their public benefits or be able to get public benefits. It does have a payback provision to Medicaid, and it requires some special forms and an attorney letter that indicate that it is the correct type of trust. So that's something to keep in mind if your child has some way of getting that military survivor benefit from you as the parent. So now I'm going to talk about the most important type of trust, in my opinion, to set up now, especially when we're in the middle of this terrible time, is a third-party special needs trust. It established with other people's money, so a grandparent's money, a parent's money, aunt and uncle, friend, anybody else's money, not the disabled person's money. Anyone can establish it, and there's no age restriction as far as establishing it or funding it. There's no payback provision to Medicaid. So what happens is, if there's any money left in the trust when the disabled person passes away, the person who established the trust, the grantor, for example, the parent or grandparent, will indicate in the trust document where they want that money to go. So it could go to other grandchildren, to the siblings, to a charity, wherever you want. Also, it can be revocable. So if, let's say, a parent were to set up a special needs trust for a disabled child and at some point needs to revoke that trust, let's say the child gets better and no longer needs it, or they need the money that they may have put in already into the trust back, they can. So it really is more flexible to have a third party than a first party. Also, it can be created during the parents or grandparents during their lifetime or at death through their will. I personally like what they call a living SNT, living special needs trust. So that allows other people to contribute. For example, let's say a parent, the parents of a disabled child set up a special needs trust that only springs into being when they pass away. And then grandpa dies. Grandpa can't leave money to the parent special needs trust because it doesn't exist, only exists at their death. So that's why a living or standalone special needs trust, standalone third-party special needs trust, is what I prefer to draft, and it's something that you should consider. Now, what can the trust be used for? For so many things. I mean, it could be used really for anything other than room and board. Room and board is something that you should avoid using the special needs trust money to pay for, because if you do that, then Social Security will do a 1/3 reduction of your SSI benefit. So you should not use it for room and board. You should not give cash directly to the disabled person. Shouldn't be used for food or groceries or restaurant meals, rent, property taxes, condo dues, utilities such as electricity, gas, and water, because you want to avoid that 1/3 reduction of the SSI benefit. Again, the SSI benefit right now is $783. So 1/3 reduction is significant. So we want to try not to do that. However, many times you have to do it because you need the money in the trust to pay room and board. So if that's the case, then as long as you make a conscious decision as trustee, then it may pay to use the money in the trust for that purpose. Now, how do you fund a special needs trust? Now, some people use cash or investments. Some people put real estate. Some get life insurance that the beneficiary is the third-party special needs trust. And that sometimes falls under a second to die life insurance of parents. And that's a really great way to fund it, because then you know that at your death, some amount of money that you have in that life insurance policy will go directly into your child's special needs trust or your grandchild's. Now, rent from the disabled person. To get the full amount of SSI benefits, in most cases, a disabled person has to pay rent to the parents if they're living with the parents. And this generally is $500 a month. So what I advise my clients to do is charge $500 rent to the child, take that money, and which they could do anything they want with it. But what they do is they swing it into the standalone third-party special needs trust. So it's a way to fund it for the benefit of your disabled or special needs child. The things that you need to not forget is to not disinherit your disabled child or grandchild. In the past, that's what we did before we had special needs trust. And that really is not something that you should be doing. You shouldn't give assets or anything directly to the disabled person. It needs to be through the special needs trust. You should have a will drawn up to pour over into the special needs trust. You want to make sure things are easily transferred at your death into this standalone special needs trust. You want to update your beneficiary forms, like in your 401k and things of that nature, to name the special needs trust. You want to tell others to contribute to the special needs trust in their legal documents. Tell everybody who may or may not be giving money to your child, because then you have more money going into the trust. You also want to write a letter of intent, or sometimes called a memo of intent, which would be something that is a way for you to contribute the information that the trustee needs about your child or grandchild, what you want the money to be used for, but other things that you only know, like they only like to eat a certain type of vegetable or something like that. So it's very important that that is written down as well. And normally, someone like me, I always give people a guide to writing a memorandum of intent. Now, this is my information. My office is in Oakton. Right now, during the pandemic, we are doing very rare in-person meetings. We're mostly doing Zoom video conferences and phone conferences. Now, so we can set that up and to have a consultation where we can go over everything that I said today and your specific needs. And then I can draft the documents, and we are doing we're trying to be inventive in how we do the signings. Most probably, we're going to do sort of drive-through signings of documents so that you can get these finalized during this trying time as soon as possible. So as you can see, there is my phone number and my address from my website and my email address. Please feel free to send questions, but also feel free to set up appointments as soon as possible so that there is no delay in getting this done. I hope this has been informative. And again, if you have questions, I may do another video answering the questions on this, or we'll do some kind of other way to get you the answers that you need. I appreciate it. Everyone stay safe. Thank you.